Hi everyone, this is Ishita, the legal intern at Lexis and Company. Now, today I'm gonna tell you all about the restitution of conjugal rights. Restitution of conjugal rights, concept and origin. RCR neither recognized by Dharma Shastra nor did the Muslim law made any provisions for it. It came with the Raj or the British rule. The concept of restitution of conjugal rights was introduced in India in the case of Munshi Bazlur Rahim versus Samsonia Begum in 1867. Hindu law under Section 9 of the Hindu Marriage Act 1955, when either the husband or the wife has, without any reasonable excuse, withdrawn from the society of the other, the aggrieved party may apply by petition to the district court for the restitution of conjugal rights, and the court, on being satisfied of the truth of the statement made in such petition and that there is no legal ground why the application should not be granted, may decree restitution of conjugal rights accordingly. When a question arises whether there has been any reasonable excuse for withdrawal from the society, the burden of proving reasonable excuse shall be on the person who has withdrawn from the society. Now, RCR under different personal laws. Muslim under general law. Christian under section 32 and 33 of the Indian Divorce Act 1869. Parsis under section 36 of the Parsis Marriage and Divorce Act 1936. Persons married according to the provisions of the Special Marriage Act section 22 of the Special Marriage Act of 1954. Under all the personal laws, the requirement of the provision of RCR are the following. First, the withdrawal by the respondent from the society of the petitioner, that is, from the totality of conjugal relationships. Second, the withdrawal is without any reasonable cause or excuse or lawful ground. There should be no other legal ground for refusal of the relief. Fourth, the court should be satisfied about the truth of the statement made in the petition. The court will normally order the restitution of conjugal rights if the petitioner proves that respondent spouse has without reasonable excuse withdrawn from his or her society. The statement made by the aggrieved spouse in the application are true, and there is no legal ground why the petitioner prayer should not be granted. What amounts to reasonable excuse? The court has held in various cases that the situation will amount to a reasonable excuses to enact as defense in this area. First, a ground for relief if any matrimonial cause. Second, a matrimonial misconduct not amounting to a ground of a matrimonial case if sufficiently weighed and grave. Third, such an act, omission, or conduct which make it impossible for the respondent to live with the petitioners. Constitutionality, belief of restitution of conjugal rights. The reality, the constitutional validity of the provision for RCR has time and again been questioned and challenged. In 1983, before the APHC, in T. Sharitha versus T. Venkasubhan, Air 1983 AP 356, where the court held that impunged section was unconstitutional. Supreme Court in Saroj Rani versus Sudarshan AIR 1984 SC 1562 upheld the constitutional validity of the Section 9 of Hindu Marriage Act 1955. Application of the provisions in different communities amount to reasonable excuse. In Hindus, any ground on which the respondent should have or could have asked for a decree for the judicial separation or for nullity of marriage or for divorce will amount to reasonable excuse. Any conduct on the part of the petitioner taking advantage of his or her own or any disability. In case of Muslim, cruelty by spouse or in-laws. failure by the spouse or perform matrimonial obligations, or non-payment of prompt drawer by the husband. Christians, in case of Christians, it's cruelty, insanity, and marries again with someone else. And in case of Parsis, deserted or without lawful cause ceased to cohabit with his or her spouse. The court, if satisfied of the truth of the allegation, no just ground why relief should not be granted, may proceed to decree such RCR. Important provisions under Hindu, Christian, and Muslim law. A petitioner for the RCR is maintainable only when there is a valid marriage. A Hindu and Christian can file a petition for RCR, while under Muslim law, a suit in a civil court has to be filed. The concept of gender discrimination has not been incorporated in Hindu and Muslim and Christian marriage, but not Muslim husband can defeat wife's petition for restitution at any time by prompting talaq on her. So steps, there are total in 12 steps to file this case for RCR. Now I'm gonna conclude that it is a remedy that it is aimed at providing the marriage, not disrupting it as the case of divorce or judicial separation. I hope you like the video. For further updates, please do subscribe the channel and comment down. Thank you.